Good afternoon and welcome to the September Residential Property Forum. My name is Robert Kelly. I'm the Director of Partnerships at Stewart Title, and we're very happy and proud to sponsor these monthly forums with IQ Legal Training. And Ian, good afternoon, Ian.
Hi, Robert. How are you doing? Good weekend?
Yes, not bad at all. I'm in sunny Sheffield, and it's very sunny today.
Oh, yes. I'm joining you on that later.
You're joining me there for tomorrow, yes. But very grateful for everyone that's attending today. We know you are busy, but as always, talking to someone as knowledgeable as Ian and talking to people as knowledgeable and experienced as the people attending today is always very useful for conveyancers. We're going to look in particular today at stamp duty from the point of view of how you as a lawyer can advise clients, whether you should be advising them, and how you should be explaining the limitations of your advice to your clients, obviously coming out of recent high profile problems over stamp duty. We all know it's very difficult, and we all see figures that are over 50% of all stamp duty returns are incorrect in some way. The vast majority of them in favour of the Exchequer, so they don't tell us about those ones, but occasionally it's in favour of your client, and that's when the problems start. So we will be looking at that. Quite interested to hear from people what you do on stamp duty. What advice do you give? Do you completely hands off and tell the client to look for it themselves? Do you just use the very simple calculator on the stamp duty site, or do you use any of these new technological startups which are providing very good information on stamp duty and be able to give you calculations on there? So we're very interested to know what you do. Please put your comments in the chat room, and similarly, if you do want to raise any questions, put them in the chat room and Ian will look at them. But first, Ian, if we can just go through the housekeeping.
Yes.
So that's first. I'll move on to the next one. We're okay there. Just to tell you very quickly about Stewart Solution and Stewart Online Solution, our online platform. We do have over 150 different policies available there. Cover for the most popular ones up to £20 million. All of our policies have 10% inflation cover for the first 10 years, which helps you with inflation there. So if you buy a policy today for £250,000, in 10 years' time, it'll be £500,000. Very simple ordering process, 3 steps and less than 60 seconds to get a quote. If problems are more complicated or over that threshold, you can deal with our bespoke team, either via the Stewart Solution site or directly. And as always, as well as these forums, we do a lot of other webinars, and we also run a commercial property forum with Ian. We are starting on Wednesday a series of monthly back to basics training sessions with Ian, where we're going to look at some of the issues you face every day, just to make sure you stay up to date and fresh on them. And also, obviously, if you've got any new people who've joined your firm, it's going to be very good for the onboarding process. So we go to the next slide, Ian. So if you are interested in Stewart Solution, want to see what it looks like, please sign up at the address given there. If you do want to talk to any of the business development team about how we can help you, training for your teams, or any topics you'd like to have included in these webinars, please get in touch with me. And if you've got any colleagues dealing with properties in Scotland and Northern Ireland, my colleague Liz Birrell up in Scotland will deal with those for you. So Ian, I think let's pass over now and start. I think you're going to start on stamp duty.
Yeah.
And over to you.
Thanks very much, Robert, and good afternoon to everyone. And a massive thank you indeed to Stewart Title for sponsoring these events. As Robert was mentioning, there are monthly forums which are free to attend. There is also lots and lots of sort of live events. So as Robert was alluding to, tomorrow we're doing some work with the Sheffield Law Society, which Stewart Title are kindly sponsoring. In addition to that, Stewart Title sponsor Property Law UK, our monthly electronic publication. And just hot off the press, on the 23rd of October, we've got a webinar with Professor Richard Sulkind, who's going to, or Susskind rather, who's going to be talking to us about artificial intelligence. If you haven't heard Richard, he's really, really interesting guy, probably the man in the world to talk about AI for lawyers. So again, massive thank you to Stewart Title for supporting that and enabling that event to happen. Anyway, lots of things to discuss today. So we'll just have a look, first of all, at some useful websites that I always mention. I was interesting over the weekend there. I was looking at Tanfield Chambers and Falcon Chambers website. There's loads of useful information sitting on both of those sites for you if you're dealing with residential conveyancing, Building Safety Act issues. But all of those sites are particularly useful for you as transactional property lawyers. Anyway, let's get down to the nitty-gritty. I want to talk about these issues. First of all, I want to talk about SDLT, as Robert alluded to. And the first thing I want to discuss is just how are you as firms dealing with SDLT at the moment? So if you could put in the chat what you're currently doing, and when I say, or when I ask what you're currently doing, are you limiting your retainer with regard to SDLT issues? Are you explaining to clients that you're not giving detailed advice relating to SDLT, but explaining general issues? Hopefully, unless you're comfortable in providing detailed advice relating to SDLT, you are covering off your risk by explaining to the client the limits with regard to your role concerning SDLT. So let's just take a step back and have a think about it. Number one, we're obliged when we're onboarding a client purchasing a property to advise them of the potential for SDLT liability. Where it is feasible and possible, we should be explaining to clients what we estimate the potential liability could be in connection with the transaction. I hope that we're explaining to the client that we are dependent on the client providing us with all relevant information concerning their circumstances in order that we can consider the SDLT position. And then I think we've got a choice to make. Are we going to give detailed advice to our clients about the relevant reliefs and surcharges that could apply? Are we going to give detailed advice with regards to tax planning relating to SDLT? Are we going to be relying on specialists to assist and aid us? In taking all of those issues in turn and looking at the need to take external advice or specialist advice, number one, there is no problem at all with a conveyancer advising a client that the transaction is complex, the client's circumstances are complex, and therefore the client should be seeking specialist advice externally to our firm in order to ensure that the correct SDLT is paid, the correct reliefs and surcharges are claimed, and that the client has received appropriate advice concerning tax planning. So we can go outside our firm for that purpose. And there are a number of companies now that are offering specialist advice relating to SDLT, offering a service to conveyancers. In addition to that, there's a few sets of counsels chambers that are specialist relating to taxation advice. And my dear friend Paul Clark is also, as a solicitor, offering advice in connection with SDLT issues. So you have a variety of external resources that you can use. Talking about external resources and just shedding a word of caution before we go any further, the HMRC has an SDLT calculator, and I think you need to be careful with regard to that. It is a rough and ready broad stroke or broad brush approach with regard to SDLT liability. I think at the last count there are 49 reliefs and surcharges that potentially could apply in connection with a residential transaction, and as I recall, the HMRC online calculator only takes into account 2 of them. The other thing to watch out for is HMRC give advice with regard to SDLT, but sometimes that advice is contrary to decisions of the relevant tribunals. So again, caution needs to be exercised with regard to it. Is there a safe way of dealing with this? I think there is. I think we say to clients that where there are complexities with regard to SDLT, we'll recommend to the client that they seek external advice, and we will get an estimate as to costs relating to that advice. The next thing that we need to think about, again, when onboarding a client, and again thinking about compliance issues, is to make sure that when we are estimating SDLT, determining SDLT as the transaction progresses, requesting funds to pay SDLT, and then submitting a return, we need to make sure that there are the appropriate checks in place and assessment of risk in place so that we're fulfilling our duties and obligations to the client. What does this mean? It means, one, when we're giving an estimate to fees or a quotation or onboarding a client, we advise the client that we assess the SDLT liability to potentially be, but advise the client that this will be subject to revision as the transaction progresses. Before we exchange contracts, it would be prudent again just to check if there's anything that we've become aware of that changes our estimate of SDLT liability or our calculation of SDLT liability. So before we're committing our client, the client is aware of whether or not our original estimate requires revision. I think then when we're sending a completion statement out to our client before we complete, again, we should check the position relating to SDLT. As far as information from the client is concerned, when we're onboarding the client, we need to ensure the client is aware of the information that we'll need for SDLT purposes. And again, I think just before we exchange contracts, it's imperative that we have all the information that we need before we do our check with regard to SDLT and calculation. And I think the next thing that we need to do is we need to make sure that where the client has provided information to us from the outset, and before we submit a return on our client's behalf, we're telling the client that we're relying on the information that they have produced originally. And if that information changes or alters, the client should be told that we need updated information. And again, a warning to the client about potential problems associated with their providing information to us, which is incorrect. At the end of the day, we are submitting information to HMRC on the basis of information that the client has provided. Therefore, we should make sure that we're not in the firing line if that information is incorrect. Just before I go any further, I just want to have a look at Lauren's point. Hi, Lauren, by the way. I inquired with SDLT helpline and they couldn't advise. Does anyone know whether a transfer of equity from 2 to 1 does a help to buy loan count towards consideration, like a mortgage, for the purposes of SDLT? Can anyone help Lauren out on that one? Again, Lauren, the SDLT helpline, I don't think is particularly helpful. I don't know what everyone else is saying. But certainly with regard to transfers of equity, SDLT is quite a complex topic. And I think what we're looking at there, Lauren, is the fact that, you know, any consideration is consideration for SDLT purposes in connection with the transfer of equity. That would be my starting point with regard to your question. But can anyone else help? But while we're waiting, this point about the SDLT helpline, again, caution needs to be exercised. Where you are seeking help or guidance from a third party, or where expert information is being sought relating to SDLT liability, a number of points. Make sure that you're recording on file what you've asked for and what you've got by way of information. And again, where you're challenging or asking a client for more information or clarification relating to information, then again, you detail what the client has been asked and what the client has provided. So again, Lauren, I'm just waiting for that. As far as that issue is concerned, I will have to scurry off and try and find the answer to it, but I'm just wondering if anyone else can assist. I'll just take a photograph of the question so it reminds me that I need to have a look at it. Right, no problem with that at all. So yeah, going back to this point then, right? When we're onboarding a client, let's have a look at first-time buyer relief, for example. So I'll come back to Lynn's point. So thanks, Lynn, for helping us there. But I'll just come back to the question. The point I was making there with regard to SDLT and first-time buyer relief, do you tell your client, you know, the detail concerning just what first-time buyer relief is? Do you explain to the client the fact if the client has any form of beneficial interest in connection with any other property in the world, then the client is not a first-time buyer? So I think in addition to providing information to the client about your role, it's also important to make sure the client appreciates the need for honesty and frankness with regard to what's disclosed to you. So anyway, going back to Lauren's point, Lynn, thank you, Lynn, for your contribution. You think it does and agree, yeah, SDLT should be paid on 50% of outstanding mortgage plus 50% of any contribution made to outgoing parties. So we've got some consensus there, Lauren, from Lynn, Mark and Catherine. So let's go with that. I'll check it up, but it certainly makes sense. And again, as far as that is concerned, a number of points to appreciate. One, HMRC aren't particularly helpful. Sometimes they will give advice or assistance, or it will be provided in their manuals, etc., which won't necessarily be supported by the courts. So I think you should always be cautious with regard to what HMRC are advising you of. But I think we've got a view there with regard to the problem that Lauren generated. Okay, next thing, with regard to SDLT and the pre-exchange sort of revision or check. Again, I think that's important. I think that's useful. Again, what you're doing is just confirming to the client what you originally ascertained when you were onboarding the client and notifying the client if there are any changes in circumstance that are relevant or appropriate. Something I'm often asked about by practitioners is where there's an apportionment with regard to fixtures and fittings. Be careful with regard to that. In the good old days or bad old days, I used to encounter firms that would just accept what the client was telling them with regard to a price being paid for contents and apportioning the purchase price and drafting a contract or approving a contract on that basis. Again, that's a dangerous exercise to undertake. I would maintain, and I'm interested to hear what everyone else has got to say, is where there's any form of apportionment that generates an SDLT saving, I would want the client to understand and appreciate the importance of the fact that the valuation or the assessment of price for contents is a fair and reasonable one, and I'm probably going to ask the client for some form of independent proof. Now, again, I'll put that to everyone attending today. Would you do that as a matter of course, or would you, which is the rule and the stance I've taken recently, is to say to the client, only where the SDLT saving is a large saving would it be necessary to get independent advice, or only where I'm unsure with regard to what the client is telling me concerning the price of contents would I say independent evidence is required. The problem with apportioning the purchase price and thus reducing or eliminating SDLT liability is that potentially, if what the client is saying isn't true, then there's fraud being perpetrated against HMRC. And the problem with that is the perpetrator is first of all the buyer, but then I have a problem with regard to the buyer's lawyer that's submitting the return and approving the contract. And I'm also potentially concerned about the seller and the seller's solicitors who've drafted the contract and in essence participated in the fraud in so doing. So again, caution necessary. Okay. Robert alluded to the Angela Rayner saga, okay, and the situation with regard to that. Of course, the issue there is this point about beneficial interests and trusts, etc. So if we were looking at that in the cold light of day, hopefully Mrs. Rayner would have been asked by her conveyancer to disclose everything and anything relevant to her existing circumstances and property ownership and the circumstances concerning the purchase of this property. And I would have hoped that the position would be in those circumstances that given her disclosure, assuming it's a full and frank disclosure of her circumstances and of this particular transaction, that the lawyers would have either said, well, yes, we feel we are competent to give the appropriate advice, or we recommend that specialist advice is sought. Again, careful. When you're suggesting to the client that specialist advice is sought, or where other lawyers are being involved to give taxation advice, be careful about scoping the retainer, be careful about clarifying with the client who's doing what. I think that's important. Right. Okay, let's just have a look at these things. Pippa, hi Pippa. I advise clients to get a formal second-hand valuation of such items and retain this on file. Agreed. If it's significant, and I request that they get and keep evidence of value in the evidence of HMRC clawback. What about SDLT on auction purchases on some such as contributions to standard legal fees? That's a great question, actually. I just want to look at that. I've seen some firms that say all of that is consideration for SDLT purposes, Lisa. Don't know what everyone else thinks. Mark, hi Mark, by the way, I'll come back to you in a moment or two. Let's just look at Lisa's point with regards to auctions. Yeah, contributions to legal fees, issues with regard to the auction house's fees and costs, etc. I've seen an argument from some lawyers that all of that is consideration for the purposes of SDLT. Now that might be being ultra cautious, so I'm interested to hear what everyone else has to say. But Lisa, thank you for posting that. I think it's a really interesting point. Yeah, right. Yeah, I think I agree, Lauren, with what you're saying. I mean, if in doubt, and I think this again, harking back to the Angela Rayner position, her mistake was, if there's, particularly in her position, if there's the slightest suggestion that SDLT could be paid, what she should have done is paid it and then argued later, rather than doing what she did and then encountering all the misfortune that arose as a consequence. Right. Yeah, I agree, Mark. Right, Mark, let's have a look at your point. Mark's always keen to contribute, which is brilliant. Right, what about where husband and wife sever the joint tenancy, make mirror wills, leaving their share to the children, but with survivor allowed to continue occupying? If surviving TIC wishes to use proceeds of sale of the property to purchase new properties permitted on the terms of the deceased will, and children wish to be made party to transfer, then if they own no property, does the trigger rate? Does this trigger higher rate SDLT, or does the fact they would not need to be able to occupy or receive income? Tricky one, that, Mark, isn't it? Is that one that you've actually got on the go at the moment, or just a hypothetical issue that's been sort of keeping you awake at night? But not be able to occupy or receive income, stipulate not. If surviving tenant in common wishes to use proceeds of sale of the property to purchase in the terms of the deceased will, no, they on the higher property. Again, Mark, my initial reaction to that is I think we're in the realms of higher rate SDLT. But again, Mark, I'm going to just take a picture of that and again just have a look at it. With like a lot of these things, you look at it at first blush and you say, oh, that's what the position is. You have a deeper dive into it and you think, well, hang on a minute, no, that might not be right. So again, Mark, that's one for the homework list. Let's just go a little further down. Right, Jaspreet. Hi, Jaspreet. Clients considering transferring their property to a family member from nil considering transfer is paying on behalf of the transfer. CGT transfers of your product. I guess this is taken to be reflected. Yeah, it would. Yeah, I think I'm entirely with you on that, Jaspreet. What about anybody else? The other thing, yeah. Sarah, thanks for that, Sarah. The other thing with that is do watch who you're acting for with regard to buyers, right? Again, in the last year, I've seen this 4 or 5 times where you've got a sort of a property club, 3 or 4 people sort of clubbing together and buying properties in connection with online auctions. And there's issues there with regard to the beneficial owner's status from an SDLT perspective. Thanks for that clarification, Sarah. Yeah, that's great. SDLT guidance. Again, just a word of caution. You'll sometimes see tribunal decisions that run contrary to guidance. I was looking at something recently concerning empty properties and derelict properties and attraction to residential as opposed to commercial SDLT liability. If anyone's interested, I think there's a case in the Estates Gazette last week or the week before about it. What about where husband and wife sever the joint tenancy and make mirror wills? This would form a trust. Yes, it would. Karen, hi Karen, would that be the same with new build whereby we contribute towards documentation? I haven't seen that one, Karen. I don't know about that. Whether de minimis comes into play there. Just had a look at that. All right, you've answered. That's fine. Ridwan, 28,000, not below the £40,000 return threshold. Anyone on that one for me? Again, don't forget, just while we're looking at that and contemplating that, We do need to be careful about other taxation issues, don't we? So if you're acting for a buy-to-let investor, you're going to be giving the client advice relating to income tax liability, etc., capital gains liability, etc. Again, we need to be cautious about that. I think, again, what we're required to do is draw to the client's attention the potential for tax and suggest, unless we're comfortable in giving the advice via our private client team or whatever, that the client takes independent advice relating to it. Okay, the next thing I want to talk about is SDLT reliefs and surcharges, and just to explain just how many reliefs and surcharges there are, and just to ensure that you're aware that the HMRC guidance and calculators don't take into account all the relevant reliefs and surcharges that could in fact apply. So we do need to be careful with regards to that. Yeah, it is, Brian. Thank you for that. Yeah. It's quite an interesting case, isn't it, Brian? If anyone's interested, I'm doing a report on that, not in this month's Property Law UK, but in next month's. But it is an interesting case, Brian. Yeah. And again, it just shows you, that the attitude of the courts and tribunals is sometimes different to that of HMRC. So you do have to be careful. Has anyone had, I hope no one has, ever had a situation recently where a client comes in and says, oh, my accountant has come up with this scheme that means we avoid SDLT, or we limit or reduce our SDLT liability? Anyone had that? I remember when I first started in practice, we had a mortgage broker who had paid a fortune to a firm of accountants to come up with a scheme to enable SDLT to be reduced, or in some cases eliminated. And the interesting thing with regard to that is, if that was today, you'd have to go to our HMRC and say, look, this is my client's scheme, can you approve it? Anything less than that would generate problems for the client. Right, new builds. I'm just going to make a note of this one as well, Mark. New builds are a problem, particularly allowances, etc. All of that sort of thing can cause issues. I remember looking at something just recently whereby, I'm just going to take a picture of that, Mark, where the builder was providing the client with a car as an incentive with regard to the purchase. Each side no payment, and therefore any deviation is part of the price. Yeah, agree with that. Otherwise, portion could be manipulated. Certainly, yeah. And in that case, with regard to the car, the value of the car was taken into account for SDLT purposes, which is quite a bizarre thing. Yeah, you've got to watch out for new builds. Okay, anyone else got any sort of issues relating to SDLT? So, I mean, all this happened with the Angela Rayner saga is that it's just drawn to attention, as these cases often do, what is good practice and what is bad practice, hasn't it? But I repeat, you can obtain specialist advice on behalf of a client with SDLT issues. You are required to make sure clients are aware of their duties and obligations. You are required to have a knowledge of reliefs and surcharges so that you can indicate to a client where, for example, specialist advice is necessary. Zara, hi Zara, multiple relevant relief dwellings removed. What do we do now about annexes? Well, yeah, the position there, Zara, is as ever to just make sure that if you are buying a property with an annex, that you are carefully consider the SDLT position relating to it. Number of dwellings, etc., can be an issue with regard to SDLT liability. The other thing I encounter, Zara, quite a lot is where you've got a large house with gardens or with buildings in the gardens, etc., and an attempt to argue that the buildings and the gardens are not garden and they should be assessed by way of a commercial SDLT assessment, with the house and the sort of the garden adjoining being regarded as residential for the purposes of SDLT, which again can be an issue and indeed a problem. Okay, anyone else got any points then with regard to SDLT that they want to explore? It really is a nightmare for conveyancers. I go back to summarize the points I made earlier. Scoping the retainer, critical. Making sure clients understand your role, critical. Make sure that clients providing you with sufficient correct information to enable you to give the appropriate advice, and in order to make sure that the appropriate SDLT is paid. On file or on your case management system, always show how you've arrived at a decision, how you've arrived at a calculation, because you can then, if HMRC come a knocking, then you can at least show, well, yeah, I made a mistake, but this is how I made it, rather than HMRC suspecting some form of fraud or evasion. Remember, as far as HMRC are concerned, theoretically, if they suspect fraud, they can go back indefinitely to look at files and look at transactions. Last question on this before we go any further. Has anyone had the HMRC come in and have a look at a file or look at files? It seems to me that rather than a sort of general look at files, what they'll do is come in and look at a transaction and ask to see the file, or come in and actually ask for a copy of the file. Has anyone ever encountered that? I'm not so sure how much resource HMRC has to carry out investigations with regard to rank and file transactions. I think where they're high value transactions, the position is different, but rank and file is different. Yeah, Liz, thanks, Liz. Great point. CQS, someone has to check your SDLT calculation. And Liz, great question, which I am omitted to deal with earlier. Is it a check when you're onboarding the client and you've been given initial advice as to what you think the SDLT will be, or do you do your cross-checking before exchange and before completion statement goes out as well? Just interested in how you deal with that, Liz, and anyone else, how you deal with it as well. If you could share that in the chat, that would be brilliant. While I'm waiting for that response, I want to just move on and talk about some other things. Yeah, before exchange, okay, that's fine. Yeah, I think that's important. The only thing I would say with regard to that is I do encounter some firms that don't check again at exchange. They'll check again before the completion statement goes out, and I think that's wrong, because there could be a change in circumstance that means before exchange there's additional SDLT liability. And how can a client authorize you to exchange with regard without knowing what his or her liability could be? Lauren, yeah, two solicitors review each other's files prior to exchange and sign off. Yeah, sensible. So that's part of the pre-exchange signing off, Lauren, yeah, rather than a separate check. That's fine. Okay, right, very good. Okay, send out SDLT calculation with case report. Yeah, Mark, that's fine. Again, when you're doing this or asking for authority, make sure that clients, if you're sending out a questionnaire for SDLT or sending out a report or anything like that, make sure the client signs it to acknowledge receipt or confirms receipt of it. Important. Yeah, great. Thanks for that, Mark. Okay, next thing I want to talk about is restrictive covenants. And the important thing with regard to restrictive covenants is there's quite a lot of case law at the moment flashing around with regard to applications under Section 84 of the Law Property Act 1925 to vary or remove restrictive covenant. And there's a few things here. Firstly, should you, if you're acting for me on a purchase and the property is burdened by a restrictive covenant, should you give me a sort of an essay on the fact that it may be possible for me to apply to vary or remove a restrictive covenant under Section 84 application? I would say in the vast majority of standard residential transactions, that is not necessary. But I do think it's necessary that I understand, if I'm buying a property that appears to be burdened by restrictive covenants, I should understand that it may be possible for me to make application to vary or remove. And I think it should also be explained to me that it might be possible to buy out a restrictive covenant. And as I mentioned to you in the past, and again, I was talking to someone about this last week, where your client is buying a property that has the benefit of the covenant, the client needs to understand that there may be circumstances where the right to enforce is lost due to delays, etc. So again, important. Why are we seeing lots of applications to vary or remove restrictive covenants at the moment? I think quite simply, and I think Robert and I have discussed this in the past, because of the relaxation of planning. So these days, it's far easier to get planning for all sorts of weird and wonderful, wacky uses. And therefore, in the past, the owner of land that had the benefit of the covenant would rely on the fact that the owner of the land that was burdened by the covenant wouldn't get planning permission. And that sort of hurdle or that sort of bar has been removed. And therefore, you're seeing more and more opportunities for planning gain and more need to rely on restrictive covenants. A few things flow from that. One, we need to make sure that our restrictive covenants, where we're drafting them, are watertight and enforceable. And number two, I think we do need to be careful about what we're saying to clients in connection with enforceability of restrictive covenant and choices relating to restrictive covenant as well. Any comments on that? I mean, again, I'll just ask you, Mark, if you're writing to me on a purchase and my property is burdened by covenants, in your report, will you have a line or two just saying to me, Ian, you know, it probably appears to be burdened by covenants, but it may be possible to apply to vary or remove them? You're not going to give me an essay as to how to do it, but just say if you're interested in it, then contact me or one of my property litigation colleagues to assist. Lauren, hi Lauren. I had one of these listed on the seller's side saying we're not provided at first registration. These predated, so therefore no indemnity insurance will be provided. Disagreed. Yeah, well, it could potentially be enforceable, couldn't they, Lauren, in that situation? Okay. As far as that is concerned, again, I would always be wary about definitively stating to a client whether a restrictive covenant is actually enforceable or not. Generally, as part of the conveyancing process, you are not going to undertake a deep dive or a deep investigation into enforceability. And the other thing is, if we are thinking about advising the client about enforceability, we need to think about whether or not it's sensible and easy just to take out defective title insurance. Mark, hi Mark, not normally give us advice unless the client aware may wish to captivity which could potentially breach one of the covenants. Yeah, so Mark, I agree. If you've got a client who's buying a residential property, there's an old covenant 1888 saying you're not allowed to manufacture or sell alcohol, then you know the issue of enforceability is highly irrelevant, and the wish of the client to vary or remove the covenant highly unlikely. But in circumstances where the covenant could potentially bite, then you've got to, I think, make sure the client understands that you haven't properly investigated. Do advise fencing covenants are not usually binding. No, that's right. The other thing, Mark, is where you have a covenant that requires someone's permission, and that someone, the original party, is dead, then there's a case that says the covenant is enforceable. I can't remember the name of it, but if anyone wants details, let me know. I can send it out or I'll make it available for our next get together. Okay, anyone else on the point? Mark's saying he's not going to give advice about applications of Section 84 or opportunities to buy out covenants. Anybody else got a view on that? I'm not asking you to write an essay. I'm just saying just mention it so the client understands that it may be possible depending on future circumstances. Okay, next thing I want to talk about, well, why wouldn't I? The Building Safety Act. I tell you what's interesting. In the last, 2 months or so, August, September, I've done quite a lot of conferences, face-to-face training, all sorts of things. And I'm still not surprised, but I'm still being advised that there are lots and lots of firms that are not touching BSA transactions. Yes, Sarah, certainly our report says we have a team who can advise on it. What about companies whose consent is no longer trading? No longer trading, but still in existence, Mark, I'd be wary. Consent still necessary. Going back to the Building Safety Act then. Anyone here in a firm that has recently decided to do BSA related work, or anyone, you know, with a firm that's looked at it again and thought, no, it's too risky? Yeah, Zara, I'm coming across it. And Mark, yeah, there's still lots, I would say probably more than 50% of firms aren't doing BSA related work. Yeah, Lady Clark bought a new build flat and high risk buildings now been slapped with section for fire safety work. Don't act. Yeah, done a couple for existing clients, says Catherine, but preference is not to. Yeah, I agree. So there's still, so I don't think the advising. Yeah, Lucy, thank you for that. We have a specialist team, says Annabelle. We do within our firm where we locate the many around us. Yeah. There are some firms that have to do it. Okay. Yeah, And Zara not allowed to act too potentially litigious, so many firms are not taking it on. Yeah, that's right, Jaspreet. The point is that the point I want to make is, even though time is passing, clarity with regard to the Act is sort of still poor, to be honest with you. Not many decisions of upper tribunal or court of appeal or Supreme Court are really helping us. There's just been a case involving Alicante. Don't know if you've seen it, but that case is quite interesting because once again, and this is the upper tribunal on appeal from lower tribunal, sort of explaining that really what the tribunal should be doing is giving effect to the spirit of the Act. And the other thing in Alicante, which is really interesting, is the fact that the upper tribunal was referring to the paragraph 13 of Schedule 8, legal presumption. Remember, this presumption, this is something that practitioners widely aren't appreciating. It's not necessary to verify status or ownership or occupation as at the 14th of February 2022, where you have a situation where a leaseholder deed of certificate has not been served on the landlord and the landlord hasn't requested it. So where you're worried about whether you can rely on a leaseholder deed of certificate, the issue really is, can I rely on what the producer of that certificate or the party that's executed that certificate, can I rely on what they're saying in connection with ownership or occupation as at the 14th of February 2022. And the point there is, if you can show or establish that the landlord hasn't got a leaseholder deed of certificate and hasn't requested a leaseholder deed of certificate, then the position is that you don't have to worry about ownership or occupation as at the 14th of February 2022. The lease is deemed to be a qualifying lease. So, right, Zara, government still happy under 11 meters, there's still fires in these buildings, common sense is not being applied. Yeah, Zara, the point there is you've got the Grenfell inquiry report saying, you know, height or number of stories is irrelevant in determining the status of a building. Someone where the building became BSA affected, landlord built on top, further we get away from the less likely you are going to get a landlord certificate or leaseholder deed of certificate. Agreed. Yeah, Zara, this is one of my crusades. Unfortunately, you could be acting in a transaction to which you think the Building Safety Act doesn't apply. But a landlord could either undertake airspace development and build upwards so the building becomes a relevant building, or more significantly and importantly, a higher risk building. And in those circumstances, the Building Safety Act could apply. So you could be acting for me, Zara, and buying a flat in a 3-story building that doesn't exceed 11 meters in height. Landlord all of a sudden builds a huge airspace development and adds another 10 floors onto the building. Then the building becomes a relevant building and a higher risk building. The fact that it's a relevant building wouldn't really be detrimental to the existing leaseholders, but where it becomes a higher risk building, 1, terms are implied into all residential loan leases, and 2, the service charge is likely to rocket. So can I assume then, with regard to the BSA, that there hasn't been a lot of movement with firms saying, oh, we're now happy to act, or we're now prepared to act? Has anyone heard of, I haven't, heard of any claims being made against lawyers related to the BSA? I've heard of one notification, but I haven't as yet seen any claims that are BSA related. Anybody else? Just not happening. And I don't think insurers, although bleating and saying they're worried, saying that, you know, there's lots of claims, insurers are still saying they want details from firms when they are renewing their insurance about whether they're doing BSA related work, but I'm not seeing waiting as a consequence of firms doing BSA related work, unless you can tell me to the contrary. Yeah, clients contact me, read professional negligence on a case above that one. Yeah, I think that's the big things are, and I repeat it, if you're acting for a client and you think currently the Building Safety Act doesn't apply, you should be saying to the client it could apply in the future. And where the building becomes a higher risk building, there is a risk of increased service charge, dramatic increase in service charge, and The is also terms being implied into their lease. Solicitor didn't spot all the red flags in the FRA. Okay, yeah. Again, not uncommon, Zara, unfortunately. I'm dealing with a disaster in connection with a commercial building, with a commercial tenant fitting out and not realizing that they needed the building safety regulators' consent because the building was a higher risk building, which will be a claim. Shameful on a brand new property, says Zara. Yes, it is. Agreed. Okay. Right. The next thing I want to talk about is AI and residential conveyancing. Why do I want to talk about this? Because I have, as everyone has, I'm quite sure, been aware of artificial intelligence for a while. All of a sudden, it's sort of mainstream now, isn't it? And it's in every sort of aspect of our lives. And again, from the outset, the thinking was that the first people that were likely to suffer with regard to AI, depending on how you look at it, or derive benefit from AI, were people working in the professions. And I saw a few years ago now, commercial firms looking at AI and thinking, well, we don't need junior commercial lawyers anymore because we can use AI to draft documents and to check documents, etc. So that function that was performed by junior members of the commercial team began to disappear. Whether it in fact has disappeared or not completely, I would doubt, but nonetheless, you've seen a reduction in commercial firms taking on new members of staff for that type of role. It may be that they're still recruiting staff, but looking at different types of role. There is a book written by Richard Susskind, if anyone's interested, called Tomorrow's Lawyers. I've read it. It's a really interesting book, and it tells you about, if you are a young lawyer, what you need to be doing and thinking about with regard to your career. Anyway, as far as AI and residential conveyancing is concerned, what we then saw were a lot of search companies, a lot of software companies producing things like electronic reports on title. And when I first looked at this, I thought, well, this is artificial intelligence. Now I'm not sure whether you describe it as artificial intelligence or not. The ability to migrate data from one document or one source into a document seems to be not particularly sophisticated a task when you look at what AI can do or what it's envisaged to do. But I'm sure we've all seen, and some of us are using, electronic reporting on title systems and processes that have at their heart some form of AI. What do I think about that? Well, I think anything that can make our life easier, anything that can mean we can check and cross-check what we're doing has to be useful. So any form of template or guide with regard to producing a report on title, I think can only be beneficial. However, we have to use it as a tool, and we don't have to use it as replacing us and our role. By that I mean, yes, we can use a search company's electronic report on title or a software company's report on title as a framework. Yes, we can allow it to assist us in migrating data into our report on title, but it's our responsibility and will remain our responsibility to check that what it's doing is correct. So I like any form of electronic report on title that has the source document which has been utilized to extract the data or words in the report. I like to see that on the screen so I can actually look at what's migrated, so I can check that the artificial intelligence is doing what it ought to do. So we've got that. Okay, that's fairly old news, isn't it, really? What I'm really interested in is artificial general intelligence and what else artificial intelligence can do. The idea of artificial general intelligence, as I see it, is that it goes beyond what we just talked about, migrating data from one source to another. It goes beyond searching the internet library and pulling out of the internet library topics that are relevant to whatever AI has been asked about. And what we've got now, I think, is artificial general intelligence that's beginning to sort of think and beginning to take decisions. And this is where I think things get really interesting with regard to helping conveyancers. The other thing that, and again, this is one of the themes of Richard Suskind's books, and one of the things he'll be talking about when he joins us on 23rd of October, He thinks that what artificial intelligence is going to do is going to enable firms to collaborate. And this is something that I think is really interesting. You know, every firm has a form of report on title, for example. Some firms will use a report on title that's produced by a search provider, software company, or whatever. Others will have or will have formed groups or clusters, and they will use that group or cluster to create their own form. And I think what Richard is saying is, given the power of artificial intelligence, given its width and scope, and given the expense of using it properly, you're going to see more and more collaborations with regard to systems, processes, and documentation. And that, as well as assisting in the conveyancing process, is going to mean the role of conveyancers changes. And therefore, I think that's something that we need to be aware of and alive to. The fact that, given the fact that AI is going to take over some of the work that we do and assist us with regard to other types of work that we've done in the past, the work that we'll be doing in the future will change. So it might involve more collaboration between firms, more establishing best practice, more establishing useful precedents, more establishing systems and processes, and as a consequence of all of that, more time for lawyers and conveyancers to actually sit down with clients and provide guidance and assistance. As I was saying, most of it was generic rather than doing what we need it to do, which is apply the explanation to the client's specific circumstances. I think there's a few things, Zara. One, in my sort of sad little world that I live in, I would love artificial intelligence to be able to give me a heads up, for example, about something we just talked about. Is a restrictive covenant enforceable or not? Or to determine what we should be looking for with regard to a defective title insurance policy, or what would be an appropriate piece of advice to give relating to co-ownership. So I can see it supporting us in connection with those decision-making processes. This idea about providing an explanation to clients, well, yeah, at the end of the day, this communication issues is critical, isn't it? Making sure that key messages are sent to clients and that clients then acknowledge receipt of that key message and confirm understanding of it. I think it's that sort of thing is going to be tricky. Tons of information which clients wrote. Well, it can't do that, Zara, can it? What it's got to do, in essence, is condense information or produce information in a more readable or acceptable format. And again, that's going to be interesting, isn't it? So I do see AI applying to resi conveyancing now. I see artificial general intelligence being a quantum leap from what we've currently got, being really, really useful. So I think we've got to be aware of it. We've got to look at what there is out there. However, and this is my sort of parting gift on AI, we also need to be very careful about compliance issues. I know Fiona's with us at the moment, but again, if we're using artificial intelligence, there are some really big questions relating to compliance, isn't it? You know, what is artificial intelligence? What's the source, or what are we purchasing? From what jurisdiction is it coming from? And are there any issues relating to it? Are there issues with regard to client confidentiality? Are there issues with regard to liability for errors, etc.? All of this, I think, is something that is being addressed, but I think we really need to get our skates on and make sure that we're spot on with regard to what we need to do with regard to compliance issues. Again, you know, you look at sort of ChatGPT and all of this sort of thing. Yeah, it can produce an answer for us if we ask it a question about, you know, what is a restrictive covenant, so we can incorporate that into our report on title for a client. But are we cross-checking the information that's being produced, where we're looking at it and looking at case law, etc.? You know, are we sort of second guessing? Are we checking what the AI is doing with regard to case reports? You're already seeing barristers, aren't you, getting into hot water where they've used AI to produce skeleton arguments and produce case law reports, etc., etc. So again, you know, I think we're at the tip of the iceberg with regard to compliance issues, and it's something we need to watch out for. So, question to everyone. Question number one, who thinks they're currently using AI in some way, shape, or form? And question number two, have you thought about compliance issues with regard to the sources of data and information that you're getting? And have you done a sort of risk assessment of that? Haven't deliberately, Catherine, I assume. Yeah, we use Leap, which is closed and can be verified by a real lawyer. Yeah, okay, fine. Anybody else? An AI policy, yeah, using Leap. So we are using it sort of directly. Some of us are using it indirectly. I did start to use it, now had a full AI policy circulated. Yeah, we'll check it when I get the answer. Yeah, PIPA, no. GDPR issues, access to client info. Yeah, that's the scary thing, isn't it, Pippa? And I think that's something that we've really got to take into account. So in short, I think there's some great opportunities and great ideas that AI will sort of help us with and excite us for the future. But it's early days, number one. And number two, we've got to think about compliance. And number three, we've got to think about where it's going. We're using it as a second tool, GDPR partners info, no idea, but sure, it's being checked. Yeah, absolutely. And I want to leave you with something that Richard Susskind said. The reason that I was sort of really excited with working with him, what he said was, you know, people are terrified about what AI will do. It's sort of the end of the world, and it's the end of legal careers and medical careers and all that goes with it. And what he said was a really salient and interesting point. Yeah, AI policy. Thanks, Fiona. Thanks for that. Fiona, cheeky question. Does the Law Society have any guidance on an AI policy? Just while we're doing that, okay, what Richard said was, currently AI can produce for us a country and western band, a pop band, a heavy rock band, whatever your music choice is. And that AI created rock band or band will produce music, which again will be via AI. And there'll be some people that are moderately interested in it. But people would rather see or rather hear music that has been played or created by humans and played by humans on the basis that you can marvel at their skill, their ability, their musicology, whatever it might be. And I think the important point there is that means if we put it in the perspective of a transactional property lawyer, you know, clients will marvel at just what AI can do, but at the same time will want the human touch, will want the lawyer, the conveyancer, the solicitor to hold the client's hand and say, look, I've checked this, or, you know, it's safe to rely on this. And if you have any questions or issues, then you can contact me. Thanks, Fiona. Generative AI, the essentials from the Law Society. Great. Zara, it will be like Star Trek. Law Society don't have any guidance there. Oh, yeah. But we've got that on generative AI there, the essentials. And again, my parting gift, a friend of mine who sits as a part-time judge says that judges are getting training on the use of AI. And it's not being seen as, you know, this is what you need to watch out for or be careful with. It's how useful AI will be for the judiciary of the future. So a few things. One, it's with us. Two, it will sort of increase in its use and its value, I'm sure. And as a consequence of that, you're going to get dangers to boot. What I'm going to do, Fiona, Fiona will have read, no doubt, the Generative AI Essentials. Has anyone else actually read it? I'm going to dig it out and have a look at it, I think, because A, it's important, and B, I'm very interested in it. But I think that the important thing is that we've got to make sure that we, like all things, appreciate that it's an aid to us. It's not something that sort of takes over our lives and rules our lives. Okay, anyone else got any topics? So we've got loads of stuff to talk about next time with regard to SDLT, some questions and some homework for me to do. I might get one of these companies that provide sort of specialist advice relating to AI, SDLT to come along next time. Has anyone else got any burning topics or anything that they'd like to talk about, or any topics for next time that look like to talk about? Am I right in thinking this talk about the Law Society and the client account, has that been pushed into the long grass now? We don't have to worry about a centralized client account and all that goes with it. Am I right? Yeah. Okay. Well, that's good news, isn't it? Yep. And anyone had any inquiries from developers about Common Hold and what Common Hold is and what it does? Because as far as I can gather, that's the government is on the on the run with regard to that and wanting to push it through for new builds, not for converting existing leaseholds. More shared ownership. Yeah, we might have a chat about shared ownership next time, Zara. That would be a useful topic to explore. So we'll do that. I think that would be good. Anyone else got any topics for next time? Fiona, it'd be lovely to have you along as a guest to talk and share with us your knowledge and experience relating to some compliance issues. If you're up for it, that would be great. And Zara, yes, you'll be trust property. So generally, or trust property in SDLT, Lauren? Trust property on just generally. All right, we'll have a look at that. Anyone interested in online auctions or auctions generally? Complex legal structures. Yeah, okay. Got that, Zara. We'll talk about that. Auctions, please. Yeah, online auctions. Okay, we can do that one. Fantastic. All right, how are we doing for time? I think we're just about out of time, aren't we? So I've got lots of topics there. A few things. One, as Robert mentioned, Stewart Title sponsor loads and loads of events, which we're delighted to work with Stewart Title to deliver. If anyone has, all right, capital gains. Thanks, Jackie. Yeah, we'll have a look at that. If anyone has any events that they want to publicize, let us know, because we're happy to do that. Fire risk assessments. Okay, Mikey, we've got more than enough, haven't we, for next time? And other things. If you've got support staff, we do a residential conveyancing forum for support staff. We also do loads and loads of training for support staff. I don't know why in the last 2 weeks we've been bombarded with inquiries relating to that. If there are any topics for training that you're interested in, I know Stewart Title are very interested in that. We've got our Back to Basics series, but we can look at other things as well. We've also got loads of conferences. Our last conference was at Southampton, which went really well. We've got another one in Leeds. We've got another one in Exeter. We've got another one in Peterborough. So do come along. Karen on AI, come along to this webinar on 23rd of October and meet Richard Suskind. You'll be impressed, I guarantee. And I'm really interested to see. What I'm trying to do is get him to concentrate on the conveyancing process and see how his knowledge sort of sits alongside what we do as conveyancers. So I'm really excited about that. Free to attend, 23rd of October. I think it's 2 o'clock in the afternoon from memory, but drop me a note and we can get your details. But on that note, what I'd like to do is, one, thank Robert Kelly and his colleagues at Stewart Title. Do talk to Robert, about the need for compliance training relating to defective title insurance. You need it and your staff. So that's BTL. We're talking about buy-to-let info, is it, Kirsten? I'll make a note of that. Pippa, drop me a note and we'll send you details about the Peterborough event. Yeah, happy to do that. I'm just going to make a note of BTL from Kirsten. Yeah, and talk to Robert about, compliance training, which you and your colleagues need to be on board with, and also talk to them about products, both their online purchasing facility and also bespoke product as well. Catherine, thanks very much for coming along and thanks for your kind words. Everybody else, brilliant. Remember, really interesting to talk to you, really interesting to hear what topics are. And it's your, I pick things. Robert and I talk about SDLT being a hot topic. At the end of the day, happy to explore anything that you want to explore. On that note, thanks everyone. Massive thank you to Robert Kelly and the team, and look forward to hearing from you soon and look forward to seeing you in the next one. Thanks everyone. Stay safe and speak soon. Bye-bye.